You're watching Bill on Bankruptcy. I'm Lee Pacchia. Joining me now, as always, is Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's fantastic, and you can find it on BloombergLaw.com, and it's also on the Bloomberg Terminal. Welcome, Bill.
Good day.
Bill, the Delaware and New York bankruptcy courts continue to dominate the bankruptcy business. I gather there are developments on Capitol Hill indicating that this reality is not going to change soon.
That's right. You professionals out there in Delaware and New York, breathe easy, because Delaware Senator Chris Coons was named as the chair of the Senate subcommittee governing bankruptcy. And to me, this means ain't a chance in you-know-what that he's going to change the venue rules and end the dominance of New York and Delaware in the bankruptcy bar. And by the way, Fitch Ratings issued a report just a day or so ago where they said that if the venue rules were changed and companies had to file at home, in their view, it would make reorganization more lengthy and more expensive.
So our case of the week is GSC Group. It's a little-known bankruptcy case where the United States trustee wants law firm Kaye Scholer and financial advisor Capstone to disgorge every cent of a $15 million bill. It's a lot of money. What are the latest developments?
Very interesting case, going to get more so. This is either a situation of a major conspiracy between lawyers and a financial advisor, or, on the other hand, an unfounded technical objection by a U.S. trustee who's just out to get somebody for no particular reason.
But when you say conspiracy, it makes me think we're talking about more than fees here.
Exactly. I have never seen U.S. trustees file such a lengthy pleading in the first place, like 115 pages. They're out for bear. Now, here's the deal. There was a failure to disclose exactly what the relationship was by this chap named Robert Manzo, a very esteemed turnaround manager.
One of the best.
And his company, Capstone. They said in their filings that he was an executive director at Capstone. Turns out, in reality, he was an independent contractor by contract. The U.S. trustee says that as a result, he was not entitled to share fees, a real no-no, with Capstone, and therefore wants the lawyers to give up their fees because they wrote the papers that misrepresented the situation. Kaye Scholer has obviously opposed, and they said basically, mea culpa. They admitted that mistakes were made, but said, listen here, we didn't know these details, don't blame us. Capstone and Robert Manzo looked the U.S. trustee straight in the eyeball and said, you're wrong on the law. They contend that the relationship that Manzo had is the same as that as a regular associate with a law firm, and the law explicitly says that a regular associate or somebody in that situation can share fees. This puts Bankruptcy Judge Shelley Chapman right square in the hot seat. Because in reality, I suppose there were some technically incorrect disclosures that were made. Now, what is she going to do? Is she going to let them off the hook because they are esteemed professionals, or will she throw the book at them? Win or lose, I expect to see them take this thing up on appeal.
What a mess. And really interesting stats section this week. Bill, several times we reported in these videos how junk bonds are selling like hotcakes, but you ran a story in your column about how student loans are growing in amount and defaulting more than junk debt. What are the details?
Yes, sirree, Bob. Here's the story. The amount of outstanding student loans has grown by 75% since 2007. The total aggregate outstanding now is about $900 billion. In other words, darn near $1 trillion.
75% growth since 2007.
Now, that isn't a bad thing necessarily, because it means people are going back to school, and Lord knows in this kind of an economy, they need better training, better education to get a better job. At present, about half of all of the loans are in what's called deferral status, which means that the folks are still in school and don't have to pay interest. Question is, when they come out of school, will there be jobs for them, and will they default? Because here's the number, Lee. Already 12.3% of all of the federally secured loans are in default. That is more than twice as high the default rate for mortgage loans, and about 10 times the default rate on credit cards. One of these days, Lee, unless this economy improves and people can get jobs, I think we're going to see the federal government basically declaring a moratorium on the collection of student loan debt.
Bankruptcy Judge Allan Gropper has a mammoth job ahead of him in deciding the $14 billion lawsuit by Tronox creditors against Kerr-McGee. What issues are jumping out at you when you look at a trial like this?
Well, for you bankruptcy mavens out there, this is the perfect case for the question of whether or not a Stern versus Marshall objection can be waived. This lawsuit was started a long time ago, but after it was in process, the Supreme Court said that cases like fraudulent transfers cannot be tried to conclusion in the bankruptcy court. They really have to be decided finally in the district court. As I said, it would appear that Kerr-McGee waived this objection, and the trial is now finished. And let's take the following example. Let's assume that Gropper rules that Kerr-McGee is liable for $2 billion. Now, I'm just pulling that out of thin air. They might not be liable at all, but let's say that's what he rules. A district judge on appeal says, no, the Stern objection was not waivable. I review the trial transcript from the beginning. I conclude there is no liability. That, therefore, will starkly raise the question of whether these Stern objections can or cannot be waived. And one of these days, my friends, this issue simply has to be decided by the U.S. Supreme Court. If they can't be waived, it means that a lot of decisions made by bankruptcy judges may not be worth the paper they're written on.
All right, and finally we have advance sheets. Bill, the First Circuit Court of Appeals in Boston handed down a decision that's not exactly good news for people whose homes are underwater. Tell us about the decision and what it means.
In general terms, it tells us that you cannot walk away from your underwater home by filing bankruptcy. And by underwater, we don't mean flooded by Hurricane Sandy, but rather a home where the mortgage is more than the property is worth. The court told us that you cannot force a lender to foreclose or release a lien on a home. This has the effect of making a bankrupt potentially liable for future liabilities in connection with that property, such as tort claims or perhaps common area maintenance fees. Now, I learned in the process of my research that some lawyers in Florida have found an end run on this problem. Florida, as you know, has many problems with foreclosed properties. Nevada also has huge real estate problems, but get this, Lee, I have learned from, shall we say, reliable sources in Nevada that the lawyers out there have not adopted and don't use any end runs to try to get rid of this problem that afflicts people whose homes are not worth the debt.
All right, Bill, thanks for that. That's what we have for this week. If you'd like to learn more about the cases and issues we just discussed, be sure to go read Bill's column. Again, it's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube, and of course, you can follow our updates on Twitter. I'm Pacchia. Thanks for watching, and see you next week.